we're talking about the issues surrounding those 6 judges who were not appointed by President Uhuru Kenyatta due to what he terms as integrity issues. And according to legal minds, he has no regard for the law due to this decision he took. Agwanda is right here in studio. I'd like your take on this, even as we finalize on the talking point. We have judges who allegedly have integrity issues on one side. The question would be, why not make it public? And this quagmire that has been ongoing for over 2 years now.
Let me support Mheshimiwa Tandaza 1 minute.
Okay.
Before on his party leader. 202 is when I respected Mudavadi. He ran, I think, with President Kenyatta then. Yeah. He lost the seat and refused nomination. No politician has ever done that in this country. That sets him apart as non-selfish, as somebody with some principles, and maybe actually we have never given him space to understand him.
Okay, Agwanda, over to you now.
When we talk about Chapter 6, leadership and integrity, we're not talking about something that is out there that nobody sees, but that's something that is expected of every civil servant in this country, including the president. When you have an issue with the judges, the procedure is very, very clear. The president is one endowed individual in this country with the intelligence that is above any other person in this country, because he gets briefed every single day, and billions are located to gather those intelligence information either from police, either from DCI, or from all sectors of government, even from the private sector. There are people that they pay to give them information. Among the 6 judges that perhaps were not promoted as a result of the president saying, "I do not have faith in you," basically that's what the president said. President, if he had any evidence of misappropriation or corruption or integrity issue, he should have submitted those details and information to JSC. JSC then would have used that information when they had a window for any complaint that might have been there before the interviews. Those information should have been used against or for the judges that have been left out. Remember, the situation is a little bit fluid in the sense that in the 6 that were left out, some names that were previously included were removed, some names that were previously not there were added. And the question is, why do we seem to be having names added and some removed even after the president had questioned their credibility before? That means there's a personal interest, and that means it's not in the interest of the good work the JSC has done, but it's in the interest of individuals that are feeling scared because of perhaps the cases that are having before the court. Now, when you threaten judges without evidence, and yet courts, a judiciary is a place of record, then you're shooting yourself in the foot. Because there is something called collective responsibility. For those who went to college, it was Kama Nisisi, it is our time. And I can tell you for free that you're still going to those very judges, either at the Supreme Court or at the Court of Appeal to seek for redress. The president has been cited that he can be prosecuted as an individual. First, the president needs to know that he must clear his name first. Who will clear his name other than the judiciary? It is the judiciary that he'll go to clear his name. And it might be today that the Court of Appeal will clear his name. What if somebody goes to court tomorrow after this judgment and goes to the Supreme Court and the Supreme Court retains it? How many cases will follow the president once he's out of the office? You need to be very, very, very clear on this. And I think there's a problem here, Jesse, with the people we've employed either at the Attorney General's office, at the Solicitor General's office, or advising the President on matters of law. Because all this judgment that have taken place remains low until again challenged at the higher court. And what does that mean? That if there are CASs that the court have declared that it's illegal, and you're still paying them salaries, what will happen when President Uhuru is gone is perhaps there might be a court case that is saying, for all those salaries that you've earned when you are illegally in the office, return them back. Now, where are they going to get the money to do that? Because you are having a government that is perhaps not being well advised. Maybe we need to look at the office of the Attorney General and say, are we advising the president properly? And if indeed we are advising the president properly and is not listening, then perhaps the Attorney General need to come out and say, I have done my duty, but my boss has refused to listen to me. To that point, then we will know that they're doing their job and it is the president that is not listening. To this point, the president must know that if the former chief justices are saying this is wrong, and all the legal experts are saying this is wrong, there must be something wrong. It cannot be that it's only his people that are right in this case.
Interesting. So legal advisors put on the spot right there. Professor, as you add your point, I'd like you to finalize with your contribution on the actions by the current Chief Justice, Martha Koome. Others argue that her presence during the swearing in of this 34 judges was an illegality in itself. She was stamping an illegality by not going the other way by a predecessor, all or none. How do you read from her moves?
That puts me on the spot, but let me just say this. By date of Article 99, Sub-Article 3, even if there is issues on those judges, they should still assume office. Article 99 is Article 3 is what I consider a gangster clause in our constitution, because it says it doesn't matter if you have murdered somebody and you have been convicted, as long as an appeal is pending, you still assume office. That's what that clause says in simple. So whatever these people may have done, they still shouldn't have assumed office as long as the appeal and the revisions and all those things are pending. That's the law. It was put there. I don't know who put it there, because for me, I think it shouldn't. That clause should not have been there, but it's there now. It's our law. So that is one. Number two, I think the Chief Justice was between a rock and a hard place. The president had appointed these people. They didn't want to lose. They wanted their elevation in themselves, the 36. Because they are so ready. I mean, you saw them, they were announced today, and then tomorrow they are in their ropes. So those ropes must have been made 1 week early. So what do people want the Chief Justice to do? She needed to go there because they need to support our colleagues. She can go there and then still campaigning for the other 6. So I don't know, you know, I'm a compromised person. I get, because of my training in peacemaking and all that, it tells me that it is always good to walk the middle ground. So it's clever for the CNJ to have attended, and then he turn around, then he quietly asked the president to please appoint the other 6.
Okay, so her priority was getting the appellate court up and running, according to you.
Yes.
Okay, Kasim, briefly, 1 minute, your take on the actions by the CJ.
I think that was the right thing to do from where I sit, because remember, even during her interview, one of the main questions that she had to really go deep is, how are you going to clear the backlog of cases? And certainly the backlog of cases, amongst the many reasons, is the lack of enough judicial officers, a lack of enough magistrates and judges. And this is where you are. Okay, right? What the president did legally is not right, but would 2 wrongs make a right in any case? If she say, now I even don't need the 36 judges, and yet she's supposed to clear the backlog. Remember, she said she's going to try very hard to clear. And you know, justice, delayed justice denied, we know, even in matters corruption, people engaging in corruption at highest level, knowing very well that those cases will be concluded when they're in the graves. And you know, once you die on a criminal matter, I think it also dies, and people are alive to that fact. So she did the right thing.
Okay.
On matters about ignoring court orders, give me 1 second, or probably 5. Justice, the former Chief Justice Maraga gave an earth-moving judgment in nullification of the presidential vote in 2017. It had never happened in Africa. I didn't expect it, even me. By that time, I was already sworn as an MP. And I was not even listening to his judgment because I knew, who will nullify a presidential vote? But he did. And for that matter, the current president, Uhuru, actually abided by that ruling. To me, that was a very momentous moment. For the first time, an African president agreeing that the courts have ruled against an election, and he says, well, I'm not happy, I'm not amused, but I'll abide by it by going for it. So I think sometimes we need to balance in terms of, well, ignoring court judgments is not the best thing to be done by anybody.
Right.
But up to that moment, to me, I think I will be proud of this country that we are the first in Africa for a sitting president agreeing for nullification by a court and going for another. And I think it's out of that that other countries now have started following that kind of thought going forward.
He definitely set a precedence. But speaking about a sitting president and the courts, he actually went back to the courts accusing the High Court of taking advantage of his status as the country's head of state to infringe on his individual rights as a voter. All this to do with the BBI. Now, the president made these submissions just yesterday in his record of appeal challenging the decision by the High Court that annulled the Building Bridges initiative, declaring it illegal. Take a look at this report by Murimi Mwangi.
After weeks of criticizing the judiciary over the May 14th High Court ruling that seemed to stop any further attempts to amend the Constitution, President Kenyatta has formally challenged the verdict at the appellate court. The head of state has no kind words for the five-judge bench that stopped the initiative between him and ODM leader Raila Odinga. Kenyatta claims he was never served with any court papers, despite being adversely mentioned by the parties in the suit, including a determination by the judges that Kenyatta could also be individually sued in court, his status as the country's head of state notwithstanding, a finding Kenyatta now seeks to be declared a nullity, as it was made without according him an opportunity to be heard, adding that the ruling disabuses the doctrine of functional immunity that protects a sitting president from legal proceedings during his or her tenure, in respect of things done in exercise of his powers under the Constitution. The suit now reopening the fresh wounds of the judiciary-executive frosty relations, as Kenyatta termed his treatment by the High Court as the most poignant demonstration of unfairness by the judges on one hand determining that Kenyatta had been sued in his personal capacity, then on the other hand denying him what he calls basic legal safeguards to litigants, including confirmation that the proceedings had been served on him. A protest Kenyatta sums up by affirming that he, as a citizen, a politician, and a registered voter, is equally entitled to a right to participate in amendment of the Constitution by popular initiative contrary to the High Court finding. Also enjoined in the High Court case is Odinga, who has submitted his record of appeal alongside the BBI Secretariat co-chairs Dennis Waweru and Junet Mohamed. The trio now accusing the High Court of erroneously attaching President Kenyatta to promotion of the BBI bill, a role they argue had been long taken up by the BBI Secretariat, and that the said Secretariat had no legal connection whatsoever to the BBI Task Force or Steering Committee. Electoral body IEBC has also filed its record of appeal, faulting the High Court's finding on the lack of extensive public participation on the BBI bill, and the judge's ruling that IEBC lacked quorum to oversee the process, a finding IEBC claims was not founded in law, as the commission is duly constituted, to the extent that it meets the basic threshold of 3 of 7 commissioners. This issue, the IEBC argues, had been settled by the High Court.
Council and parties, we apologize.
The appeal has already gone through the pretrial conference that tasked Appellate Court President Daniel Musinga to constitute a bench of 7 judges to hear and determine the appeal, with the hearings slated for later this month. Muremi Mwangi, KTN News.
So that's the latest. Just yesterday, the president joining in his onslaught of the decision by the courts right there. And let's just discuss it briefly and not expansively, right? Because it's an issue before the courts. Professor, I'll just begin with you. Can the president be looked at as a voter?
Well, I wish the president the best. I hope that happens, but I don't know. When you look at Article 1, I think I listened to that judgment very carefully. The basic, one of the defining things they said for me as a commoner, they said that once the power is delegated to you, you are actually no longer Wanjiku. You are now working on delegated authority. I don't know how the judges are going to find a language to overrule that statement because it's based on Article 1 of the Constitution. So the president is not just a voter, he is the president of the republic. You know, he's not a voter, but they're
approaching it in this scenario that the Constitution does not expressively define who may promote a constitutional amendment process. The right to start that initiative is open to any person, according to them.
It really does. The Constitution does do that. In Article 256, it says the sitting government, the people with the delegated authority can change the Constitution through Parliament.
Okay.
Then he says the ones, the Wanjiku, those who are after you delegate in 256, the 257 comes and says if Wanjiku has a banning issue, which means constitutional change, then the Wanjiku can prosecute that through Article 257. So, and I think this, I'm waiting to see how the Court of Appeal rules, but I listened to that in judgment very carefully, and let's be just honest, really. What is in contention in BMBI is just two issues only, expansion of the executive and the expansion of parliament. Now let's look at what does the extension of the executive does. It changes the DNA of the current constitution. Can you change the DNA of the current constitution without repealing the existing constitution? The court said no. The court said you need to repeal the current constitution if you are going to have an hybrid where you mix executive and parliament. Now, I want to wait for the decision of the court and see that, but it's good. Okay. We seek clarification, that's why you go to higher court, and eventually I think this thing will run to the Supreme Court for finality, eventually, because none of us is really an authority on this, and that is why the government right now has all those battle of lawyers, but also there is another thing you shouldn't miss in that judgment. Okay. They said that the whole process of BMBI was executive driven. When the government appeals, it confirms that statement.
Okay. Technicalities in courts and whatnot. Kasim Tandaza, your take on this. You're a firm supporter of BBI. I wonder how you see the appellate process playing out.
I'm not just a firm supporter of BBI. I'm a firm supporter of what is contained in the BBI, irrespective of the messenger. And I've never agreed with the professor because he sometimes tends to be quite economical with words, having been a former commissioner of NCIC when he quotes even Article 1 about the Kenyan citizen being supreme and exercising his powers through himself or through delegated. I don't think it goes to say that nowhere that once you are delegated, then you cease to be Wanjiku. I think you seem to be quoting that, and I think it's not in the Constitution. And I think it would mislead the public thinking that it expressly says... I'm not the one who's quoting
is the judges.
No, the judges could have said, but when you go to the Constitution now, which is the mother of all laws, nowhere does it say that once you're elected like me, then you cease to be Wanjiku. There's nowhere. Let's be very honest. Probably that's what you want it to be, but currently it's not there. Let's face the facts the way they are. And when it comes to the matters of changing the foundation, yes, you've put it correctly that you need to change. So how do you change it if you cannot either use the popular initiative for this case because we are not in parliament, not the parliamentary route, we're on the popular initiative. And that's what was being done to change it. Now, if you say you can't change it, you can't do this until you change this, and the process of changing, you say you can't do it again. So we are saying, ultimately, we'll never change this constitution. Does it serve us well? Of course, even by the time we are passing it, we say 80% good, 20%, but for how long are we going to remain with the 20%? In any case, as we put it correctly, the contentious issues is about the expansion of the executive. What brought the issue of the expansion? To me, the main issue is about our violence. You see, after every 5 years, the way we handle our elections after every 5 years. We are talking about matters economy. How did we reach here from 2007 when we were at over 7% growth up to 0? It's about our election and violence. So anything that would bring that sanity into the issue of cycle of violence, to me, it should be explored. And about Wanjiku, even in the current scenario, whether technically it's legal or not, the final say remains with the Wanjiku at the referendum. So I think, to me, from where I sit, let Wanjiku be given that opportunity to say yes or no at the referendum. Right. The others are technicalities which the courts can well handle. But as they do that, let them also have that notion that Wanjiku has the final say on this matter's constitution, and let it be there for Wanjiku to decide.
Gwanda, add your voice to this. Did the decision by the courts, in your view, take away the sovereign power of the people to determine their destiny? Because that's the argument right now.
Let me tell you that our constitution has been changed in this country. Section 2 was changed, and it was an initiative of the people. When people said that Section 2A had to be changed. And it was changed. 2010 Constitution came up, and it was changed. And it was done by Wanjiku, a popular initiative. 2017 came, not 2017, but we're talking about 2020. You know, the BBI that we are changing today, I don't know which year it's falling, because it began 2 years before 2020. It came, and then it has found us in a court of law. The question is, what is the difference then? That prosecutes what Mheshimiwa is talking about. If then you're saying that you're not Wanjiku, you're Wanjiku and you're already elected, then why didn't we have the same problem in Section 2A and 2010 Constitution? Simply because the government was not part of it. They had to be part of it because the popular initiative had been driven to a point where they could not stop it. But in this case, we have the government and the Wanjiku at the same place. That's where the confusion is. Hence the reason why a constitutional court has decided that this is illegal. So who am I to say that any other person is Wanjiku? It doesn't matter whether you're president or a member of parliament. When you become a member of parliament, you're delegated the responsibility of representing your constituents. You cease to be the person who drives. You need to represent them. And that's where we're having issues where roles are inadvertently being used just haphazardly, simply because people doesn't seem to understand where they are. And I think the president doesn't seem to understand where he is today, because he's the president of the Republic of Kenya, and he's also saying, I'm Wanjiku. But the Constitutional Court is saying, you're not Wanjiku, you're the president of the Republic of Kenya. And so that's where the confusion is. And to that point, now let's go back to the roles, so that it is not just about putting lawyers out there to prosecute a case, to even a point where you know very well that the Constitutional Court has decided on this matter. And going forward, as Professor has said, I see a situation where basically we're still going to go up to the Supreme Court. The question is, even if we got it at the Supreme Court, because now there seem to be a lot of threats within the judiciary, will we have won, will Wanjiku have won, or the executive will have won in this case? I think that's a fundamental question. Because there is a possibility, as Maraga has said, that if we go to this, we go full hog the way we're going, where we're threatening judiciary by taking positions and giving others position, that maybe judgment will not be done according to the law and the interest of the people, but it will be done according to the executive, which to me is what Maraga is saying, a banana republic. We don't want to go that direction, where you're forcing yourself, because people are already calculating How many, people from Central Kenya are in, Supreme Court? Or, how many judges are from Central Kenya? They're already adding up and taking and subtracting. Is that in the interest of this republic? Really, we have to know that the President of the Republic of Kenya ceases to be Awanjiku. He is having an executive authority. It doesn't matter how you argue it. It is the fact and it's the reality, because that's why he's a symbol of unity of the whole republic. As I conclude,
yeah,
let judiciary do its work without feeling that they are being threatened by the executive. When the judiciary just the other day overturned the restructuring of government, including the judiciary, that was actually petitioned by the president, then there was an issue. You can see the judiciary is saying, as he was saying, that look, if you have to change the governance of this country, then start by changing the law, not restructuring government.
Okay.
I wish
Professor Final.
I really wish BBI was done properly, because there are two things I saw it doing.
Yeah.
First, Regular talked about equality of vote. BBI was correcting that equality of vote.
Okay.
Number 3 is the money that we give to the counties. For whatever reason, the Central Kenya leaders left in Naivasha, and that formula right now is really skewed. BBI was changing that formula. And so for me, I wish it was done correctly so it passes.
Okay.
But the court said it was not done appropriately, and me, I trust the court.
The process, okay.
Yes.
Kasim, I'll give you barely 30 seconds. I'll
Exactly.
have to cut you short.
I think we need to be realistic here. When it came to the issue of multipartyism in 1992, it is not, okay, there was clamor for multipartyism, but I remember in Kasarani, before the president spoke, the people in Kasarani had said, no, we are better off with one party. The people in Kasarani, and they were from all over Kenya. So it was also a presidential pronouncement from the late Moi, who said, to repeal, and everybody then clapped. So in matters constitution, I think they normally start from the executive. They have the final say. Even in the constitution that you are talking about right now, okay. I remember the former president campaigned for this constitution, and he was in office. Mwai Kibaki campaigned for this constitution that we are dealing with. So what has changed now? What has changed now is 2022 politics, okay. Presidential vote.
Let's finish it at that particular point. Let's see how it plays.